Welcome to the Oregon Family Law Series brought to you by the Center for Nonprofit Legal Services. Today, we're talking about litigating custody and parenting time in the Oregon Circuit Court. My name is Ray Churba. I am a licensed attorney in the state of Oregon, and I litigate family law cases for the Center for Nonprofit Legal Services. So we're going to start by talking about custody. It is a very big topic. There are some misunderstandings out there about custody. And in this video, we're going to talk about what custody is, what it is not, what goes with custody, and how custody is litigated. Custody is the ability to make major decisions concerning your child, including but not limited to the child's residential education, healthcare, and religious training. That's what custody is. Sole custody means you can make these decisions on your own, and if you have joint custody, you make these decisions with the other parent. I frequently hear the term physical custody, and that does not exist in Oregon. In Oregon, ORS 107-105 authorizes the court to award sole or joint custody. Those provisions regard decision-making, and there is no authorization in any Oregon statute for a court to award physical custody of a child. So physical custody in Oregon is not a thing. Now in Oregon, a court can only award joint custody if the parties agree to it. If the parents don't agree, then joint custody does not happen, and the court is required to pick one parent who will receive sole custody and the other parent will get no custody. This is a list of some other things that you can do with your child if you have received sole custody from the court, as told to me through the years by my clients. You can relocate out of state with the child. You can decide what information the other parent can have about the child, and you can control the parenting time of the other parent, including when they see the child and what they do with the child. And as you hopefully guessed, all of these are incorrect. And we're going to go through them one by one. So as far as moving out of state, Oregon has a statute 107-159, and it makes no distinction between custodial parents and non-custodial parents. Either parent that wants to move more than 60 miles further distance from the other parent is required to give the other parent reasonable notice of the change of residence and also give a copy of that notice to the court. The statute does not say how far in advance the notice must be given. It must be reasonable, though, and the statute is designed so that the non-moving parent will have enough time to go down to court and file for a hearing, file their objection so that the court can resolve the issue and decide whether the parent can move over the other parent's objection or not. If you are the moving parent, the important thing to do is make sure that you give notice effectively and make sure that you can prove to the court that you gave notice. I have seen children brought back from other states when the parent that moved could not prove that the notice had been given. If you are the non-moving parent and you object to the move, the important thing is to get down to the court immediately and file your objection so the court can decide whether the other parent can move with your child or not. Sole custody does not give you the right to control what information the other parent can have. Oregon 107-154 talks about that the custodial parent shall not deprive the other parent of the following records. And you can see on here, there's all kinds of school records, medical records, psychological records, government records, law enforcement, dental. So don't think that if you lose custody of your child, you do not have the right to get information about your child. You do, unless the court orders that this provision does not apply. And if you are a non-custodial parent who is worried about the other parent moving away or the other parent denying you information, the best thing that you can do is make sure that the language from this statute 154 and the language from 159 is in your order. That way you're protected and you can give your order to a provider and get information from them, and the other parent also knows that they can't move away without giving proper notice. Now, sole custody does not give you the power to control the parenting time of the other parent. Oregon has a policy that it is in children's best interest to have frequent and continuing contact with parents who act in the best interest of their children. And whenever a court renders a custody judgment, it also makes a parenting plan and enters a parenting time order. And the custodial parent does not have the authority to change that parenting time order. Both parents are bound by that parenting time order. And if you are the non-custodial parent, you have the right to get the parenting time that has been awarded to you by the court. So what kind of parenting time can you expect if you are a non-custodial parent? Well, the worst case scenario for parents who have substance abuse issues or present some kind of danger to their children is professionally supervised visitation at a facility where they have to pay to see their own child. The best case scenario is 50% of parenting time. And it all depends on the facts of your case. It all depends on how good a job you do in court and whether or not you can get the judge to order the parenting time that you believe is in your child's best interest. So what do courts in Oregon look at to decide custody and parenting time issues? And there is a succinct list, and you can find this list at ORS 107-137. And I cannot overstate the importance of this list when you do a hearing on custody or parenting time. These are the things that the court wants to hear about. These are the things that the judge is directed by the law to consider in making these decisions. And in my experience, it is not at all unusual at the conclusion of the hearing to see the judge pull out this list of these factors and say, as to factor A, here's what I heard, here's the parent that I think this factor favors, and then just go down the line of all the factors and award custody based on which parent tipped the most factors. So when you do your hearing, you're gonna do a good job if you stick to the factors on this list, and we'll go over them quickly right here. So the emotional ties between the child and the other family members. So if you facilitate contact between the child and cousins or aunts and uncles, grandparents, whatever it is, tell the judge that. The judge needs to know, hey, when this child is with me, judge, I make sure that he sees his relatives. That's a factor. It's relevant. Factor B, the interest of the parties in and the attitude towards the child. This is where you want to tell the judge how you enrich your child's life, what you do with your child, why your child is better off having lots of time with you. Factor C, the desirability of continuing an existing relationship. I don't see this in a lot of custody hearings. In most of the hearings that I do, it's understood that both parental relationships are going to continue, so it's not really relevant. Factor D, the abuse of one parent by the other parent. This can be a really big factor because if you look further down this statute at number 2, if one parent has committed abuse against another parent, that creates a rebuttable presumption that the abusive parent is not fit to have custody of the child. And so if the other parent has abused you, you want to bring that evidence to court and you want to benefit from this rebuttable presumption. And if you have abused the other parent, you need to remember this presumption is rebuttable, and you can rebut it and you should rebut it if you believe that is in your child's best interest for you to have custody of your child. So bring your information as to why the presumption should be rebutted and you should have custody of your child instead of the other parent. The next factor, factor E, the preference for the primary caregiver. If I had to single out one factor that I have seen more custody cases turn on, it is this one. If you have been the primary caregiver for your child, you need to bring that evidence to court. Anytime a judge conducts a custody hearing, the first thing that judge wants to know is what has been the schedule for this child, what has this child's life been like before this hearing, and why should I change anything? And so if you're the primary caregiver and you're fit, you have a huge advantage. Bring that evidence to court. If you are not the primary caregiver and you feel like there's a good reason why you haven't been involved in the child's life, bring that evidence to court and give it to the judge. The last factor is the willingness and ability of each parent to facilitate a close and continuing relationship between the child and the other parent. So if you've been the primary parent and you've done a good job facilitating the child to the other parent, bring that information to court and talk to the judge about that. And on the flip side, if you have been a non-primary parent and you feel like the other parent has not facilitated a close relationship between you and the child, bring that information to court and tell the judge that you would do a better job, and show the judge that that judge cannot trust the other parent to facilitate a relationship between you and your child. So those are the factors. That's the kind of evidence you want to be presenting. When you stray from these factors, you run the risk of losing the judge. So do a good job, stick to your factors, and hold your judge's attention. Now that's mostly what I have for you. I do have a couple more things that we'll go over briefly. Most counties in Oregon have a standard parenting plan. In Jackson County, we actually have 2. You are looking at a screenshot where I Googled Jackson County standard parenting plan, and both of these results came up on the very top, 1 and 2. And if you were to click on either one of these results, you would be taken into the Jackson County, Oregon Circuit Court website. So the first one is the standard plan, which is based on every other weekend. And the next one is the 60-40 plan, which gives more time to the non-custodial parent. And if you check these out and you feel like one of them would be good for your child, don't be afraid to print it up, adopt it for your particular case, bring it to court and show it to the judge. Say, Judge, I think this would be a great plan for my child. Judges like it when litigants come into court and tell the judge what they think would be a good parenting plan for their child. Since the judge doesn't know you or your child, you're helping the judge out when you do this. And sometimes the judge might just do what you want. So it's certainly worth a shot. And the last thing that I want to show you is a statute you might want to have a look at. It's 107-425. This contains all the tools, or some of the tools, that the court has at its disposal. It can cause an investigation to be made into financial issues, custody issues, and other things. It can also order psychological or mental health evaluations. The court can also order custody evaluations, which can be expensive, but they can be very helpful because a custody evaluator can do a deep dive into your case. The custody evaluator can get more information than the judge can get in a hearing that lasts a day or two. And if you can afford a custody evaluation where the evaluator then prepares a written report for the judge, it might really help you out, might really give the judge an understanding of your case that they can't get just in court. And the other 2 things that this section authorizes is the court can appoint a lawyer for the child, and the court can speak to the child at a custody hearing or a parenting time hearing. And any relief from this section that you want should be obtained by motion. So before your hearing, you make a motion, you send it to the other side, you file it with the court, and you get a decision from the judge. So that's what I have for you. Good luck in your custody and parenting time litigation, and I will see you in court.